We're on the record for Jensen versus Jensen, case 500910. Appearances?
Thank you, Your Honor. Patricia Vaccarino, bar number 5157. I'm present and appearing with Caroline Jensen.
Thank you.
Joseph Garrett, 10634, on behalf of Shane Jensen, who is appearing telephonically.
Thank you.
I guess you want to get the...
I've already said all I have to say, so...
if you want to get the defendant on the phone, or you don't need...
He's on the phone.
Oh, he is already on the phone.
Yeah, I'm sorry.
Oh, you're... Thank you, Your Honor.
Yes, Shane, you're there?
Yes, Your Honor.
Okay.
Thank you.
What's the court's you have our moving papers. I know
Page of it.
read
Do I have a proposed order?
Yes. We attached it to our last motion.
And did you do a clarification motion saying what part you didn't like?
Well, no, this is what we were initially ordered to.
I know all the initial stuff.
Okay. Yes, we.
She gave you a copy of the order that she wanted me to sign off on?
Yeah, I gave her a copy. You ordered us to prepare an order. We prepared an order.
Okay.
We sent it to her.
Okay.
She wouldn't sign it. You
Okay.
dismissed the case.
Right.
Then
I know
she
that
brought
part.
another motion. We, after that last hearing, you said, I'll give you 2 weeks to get us an order. Sent her an order. She wrote us back and said for the first time that she had, for the first time, raised several issues with the order that had never been raised before.
You sent her an order.
Yes.
Thank you. Where is the clarification motion? If you didn't sign off on
My
it.
second motion, the first one I filed, and you heard it on May 22nd, you said
I don't
you
care about
wanted-
that one.
All right.
We worked that one to death. You can have a seat.
On May 29th. That was my birthday this year, Your Honor.
Very good.
2018.
Is it your birthday every year?
On May 29th.
Okay.
I went out of my way to make sure, in a timely manner, you said within 7 days, you're filing the motion I want so I can get this order on file the way I want it. That's the way you said you wanted it done. You also told us on May 22nd that you would set that for June 13th. And I said, you sure, Your Honor? Because... So it didn't get set for June 13th. I submitted my application for OST.
I'm sorry, I had a medical emergency, so I had to move
I'm
it.
not blaming you. I'm just saying
Okay.
how it got down the tortured road.
Don't care about any of that.
Attached to that
All I
motion,
want's
Your
my
Honor,
order.
as your motion says, you're supposed to attach your proposed order that you want.
You did.
I've asked in there that you take that out and sign it today. And
Where is your...
it's right here if you want another copy.
Excuse me, no. Okay. So in your motion that you filed on your birthday, can you show me where you said, I don't like page so-and-so, line so-and-so?
Yes.
Okay? So where is that information?
Wow, we got into pleading number 5 here.
Just didn't recall seeing that page so-and-so and page so-and-so.
At number 1, it just says that the defendant has to be prohibited from modifying, adding to, or otherwise altering the court minutes to be included without any orders, without filing the appropriate motion requesting correction.
That's not answering my question.
Okay. What happened was, for the court's edification, that
Where in your motion says page 2 is not acceptable, line so-and-so, because the videotape says something else? Because that was the instructions from the order. You're supposed to...
I know I have a page, and I
I'm
just
looking
very
for it,
long
too.
because I asked.
Again.
Okay, here it is.
What page?
At page
What-
9, the defendant's
page
proposed
9?
order is not accurate.
All right, hold on. Wait. Let me get there. So of 43 pages, on
Page
your
9.
page 9, you say...
Page
you
2.
dispute page 2, lines 9, 15 to 18, and 19 to 26. Do you
Defendant
say
failed to
why?
include the appropriate amount of child support in his proposed order.
Does it say why or where I could hear that on the videotape?
Yes, you. In fact, they
does it
think
say
you made
that?
an error and you said the wrong amount.
Where is
We
it?
stipulated.
Stop, don't talk.
Yeah.
I'll get to you.
Okay.
Caroline's proposed order is attached. Defendant's 2 incorrect proposed orders are attached. That's Exhibit 2.
I'm at page.
Caroline's proposed order.
So you're at page 9. My point.
Wait. Did I order the defendant to write the order?
Yes.
So I don't care about Exhibit 1. So, okay, Exhibit 2
Well,
is the defendant's incorrect proposed orders, right?
Allegedly.
Allegedly, according to your pleadings. Okay, so you say she disputes page 2, lines 19, 15, and 18 of which one of those 2 orders, and 19 to 26, page 3, lines 4 to 6, 7, and the most recent opposed order, finally modified. And now it doesn't say anything about why they're wrong and what they should say according to the video.
Okay, it says
Where is that?
right at page 10.
Page 10? It says line
It's-
2,
well,
so-and-so
for
and so-and-so should say something else?
Page 9 and 10. At page 9, it's not something that's in the, Your Honor, it's something they 100%, they said now unintentionally omitted. Your order, right at page 9,
I
line
don't wanna
17, the defendant failed to include the, quote, unaccompanied flights for the child.
Follow
included
my
on
lips.
Page 2 of the
Follow
minutes.
my lips. It's simple. You take his order. I don't like this line here because the video at site so-and-so says something else. Or the video is has nothing mentioned about it. It is not in the video, which I don't see that on here. I don't have the time to go through all of this stuff and try to figure out what you meant to say by what you mean to say. So did you do that anywhere in here?
Yes, Your Honor. I would,
Where's the video sites
Your Honor,
in your motion? Where are, yes or no?
If I may-
Do you, I just need my answer to my question.
I
Do
can
you
pull-
have
yeah.
video sites for the corrections to be made?
I have video sites.
I didn't ask you. Do you have any video sites?
Okay, Your Honor. With
That
all
would
due
be,
respect.
that would be no?
If I may.
Yes or no? I just want to answer that question,
I
and
do
we'll
not
proceed.
have an exact transcript site for where you ordered exactly what's in the minutes. However, it's
Okay.
not disputed that you set a certain amount that was above the maximum support, and we were willing to settle that. So I hope you're not going to send us home today.
I might.
Your Honor,
Or
with
if I might, I have
respect,
video sites for each of these issues.
one other
We
thing,
want to
Your
go
Honor,
through them
is
to show why our order is correct.
they're asking
Have
to
you given that to him?
amend.
Yeah, it's in our response.
They're asking
So
to
on this first issue, if
I'm
you
not
want-
amending
They
anything.
want
don't
you
want-
to amend under
don't want you to
60A
amend.
your minutes.
I'm not-
And I'm telling you they want to add in stuff.
I
that's
am
not-
not, I don't know how hard this,
Who speaks
you
first?
guys are, and by my own admission, 100 times smarter than me. I am not the sharpest pencil in the legal drawer. But I do know how to read, give her your motion, give your order, take the order, attach the order, give me the sites where it's wrong, and you haven't done that, counsel. And now he's done something, and I guess he's given it over to you,
It's in my response.
and I don't know if you've replied with
I have replied.
sites.
This is what it
I
is.
see the reply.
What he wants to do, sometimes when you're at a motion hearing, Your Honor, you'll start saying things of what you might find at trial. What they want, which violates the rules, because NRCP 57 says you don't make findings until trial. He wants you to add in things that are in the transcript, but not in the minutes, and he wants it to be a finding to bolster the record, I suppose. So our whole argument, Your Honor, is that he should have filed a counter motion to correct, amend, or amplify.
I'm not correcting anything. I want that order from a year ago.
Then please,
No!
if you take
Had
hours,
we done it right, I would have.
I
Counsel,
don't believe why you're
have a seat,
The
counsel.
reason,
Have a
I
seat,
appreciate
counsel.
you. The reason we're here is because we keep going through this procedure where she's not following the procedure. But I have included the citations in response to her request for clarification, the actual video sites for each record, for each issue. And again, what's really disheartening is that we're getting, after you, I mean, the first order was supposed to be in February. We made the order. She never responded with any changes. Then, for the first time, we come back for another hearing. We send her the order, and then we get a list of changes. But we went through all of them, and we went through them with her. And so I'm happy to go issue by issue. But, for example, the first issue, and I'll give you video citations because they're right here. The first issue was the amount of child support. You had ordered the presumptive maximum, but she had misstated it on the record as $11.70, and it was $11.15. So she was trying to take advantage.
Objection, Your Honor.
Your
You
Honors, I never
stated
interrupt her.
$11.70.
For all
Thank
these,
you.
okay,
Objection.
for all these hearings, I've never.
It might have been
interrupted her.
11:15 at one point in time, and now July has rolled around again. Have a seat.
Yeah, you're right.
11:38 now.
You're
A year
right.
later.
Anyways, it was $11.70. One of
Presumption,
somebody's.
the presumptive
We
max is what
stipulated that long ago.
is what it is by
Exactly.
statute, even if I said it wrong.
Exactly.
And we stipulated that
And
long
she
ago.
stipulated to it at the last hearing.
It's not
Guess
that,
what?
that's not the order.
At the last hearing, at video site 1207, 35 to 55, she came in here and said, Your Honor, we stipulate that the presumptive and maximum is 11:15. Do you know what's happened? We sent her the order, put 11:15. I'm not going to sign it with 11:15 after she already stipulated to it. And then in her motion, you can see that she's still arguing about the amount of child support when we've already resolved that issue. This is why these people can't get an order done.
Nothing's resolved because everything's temporary.
Exactly.
If you guys ever get to trial,
So
if I ever open your case up
The
again.
reason why I didn't sign it is because he's adding in findings that come out of your mouth from the transcript, which is illegal.
Which findings?
I have them right here, right here.
Would have been
At
nice
page
if you'd
9.
have put them on my
Yes, sir.
list. And why
yeah,
they...
they're right here. The stipulation and order modifying decree of divorce did not modify physical custody and clearly states that any and all orders not modified. This was not in the minutes, but he wants it in a temporary order.
I have
How's
this.
The next one
Excuse
he
me,
wants.
how's that going to harm your client to have something that's actually true? If I don't modify it, it remains in effect. How does that harm your client to keep you from signing the order?
Your Honor, it's not in your minutes.
So?
You said it's supposed
How
to
does that
follow.
harm you?
The reason why it harms me is because you're wrong. The stip and order modifying the degree of force actually did modify the physical
That's
custody.
actually right. Exactly what's happening here. She
If I
disagreed
may
with what you
finish, Your
said.
Honor, can I go
I
first? Or
included
let,
her
let me
whole-
let Joe finish, since it's on our motion, and on our motion to clarify that you made me do, and I had to wait
So
3
if you
months
go-
for it. Let him go
if
for
you go
an
to
hour,
page
because I know
12
you like to hear from me.
To be honest, you didn't do it right. Go ahead.
If you go to page 12 of our opposition again, we cite you extensively, and you told her that the order was clear that it didn't modify physical custody, and we put that in there, and you said it numerous times. In fact, I've cited you verbatim and to the record, and she doesn't agree with what you said again. She said, just as she told you, you're wrong, so she won't sign my order because she thinks you're wrong.
Well, you can't find out if I'm wrong until you give an order and take it up to the appellate court for the appellate court to say,
This is so
I'm
frustrating.
wrong.
We can't get an order entered because she disagrees with what you said.
No, if the clerk thought that what you said was an actual finding, you'd say, clerk, make this finding. They met the Rooney standard. I wouldn't complain about that. But when they're saying that you're sitting here and saying it looks like you intended to not change, but if you look at the stip and order, she had an attorney, Marshall Willock, then she had an attorney, Patricia Vaccarino. He didn't have an attorney. So what you said was, it appears that the second step, when she moved to Virginia or Washington, D.C. for a minute, he moved to Washington, that's what changed. But you said it looked like they didn't intend to change. It doesn't say joint physical. It doesn't say week on, week off. It says mom gets residential school year. Dad gets specific other times not awarded to mom. There was no label. So I came back here 2 years later and said, Rivero says you're supposed to label it. And then he started time grabbing. And now he wants your finding, allegedly, which, and if I may, I have the law here, at a motion hearing, to go in there and say that now all of a sudden he's won the case. You've already found that he was on equal footing, he's going to remain there. When Rivero says, I don't do that. I look at what you called it, and then I'll look at it at the time of trial of what it really was. So what I'm saying is, that's how it harms my client. And I'll tell you one other thing, that pursuant to NRCP 12, you cannot, you should reinstate this prior record. Why would you not take this child support in this whole
I only
fiasco?
set aside the minute order. Any order I made from that hearing. I'm allowed to set aside my orders. And so I did.
Your minute order?
The record is on the videotape. I didn't strike that. I didn't make it become invisible. It's there.
So now we just need an order from January 25th.
Wouldn't that be great?
Can you please, Your Honor, just take a look at both orders, see which one you like better. And I'm telling you why.
Oh, because
it's
you
violating-
guys aren't going to appeal that.
This,
Because she won't follow your procedure.
This is it's a temporary.
Well, then why
order.
aren't we moving
It's not
forward?
appealable.
Here's
You need a temporary order.
Here's the thing. I'm talking to the clients now.
What's wrong with our order? Ask him what's wrong with it. It just doesn't include findings that he cherry picked.
You did not specifically give me what I wanted. That's
No,
what's
he
wrong
didn't
with
give
it.
you what you wanted.
No, you didn't. Where's
Okay,
your
then
video
do this,
site?
Your Honor. Take a look at his order that he proposed, and if it's wrong, don't enter it, because you're going to find these additional findings.
Just
You're going to have to find a
quit
transcript.
deflecting, because if you had done it right, I would know exactly where his problems were.
Don't
Yes,
blame- Your Honor, with due
I am
respect, you
absolutely.
can't blame me.
I am
He
absolutely.
did not prepare it right, and he said not.
And if you don't stop talking over me, Miss Vaccarino,
Where's the unaccompanied minor flight order? He said he unintentionally omitted it for 60 days. Are you, and you're upset with me?
I am.
That I put it in my order, but
I
he didn't
am.
want to include it in his? Why are you
I am
upset
very
with
upset
me?
with you. Because at the last hearing, I was clear that you had not done it right, and instead of doing it right, and you argued with me for a long time that you did it right and it didn't matter if you did it right,
I didn't say that.
basically.
I asked you.
I'll paraphrase.
You're supposed to enter your orders, Your Honor.
I
I've never
did.
seen this in 25 years with respect. I don't understand what's going on, why you refuse to just pick an order that's right or enter your own. Enter your minutes in the form of an order.
That's not how I've ever done things in 20...
I've never in my life seen anything like this happen with an order.
Over the course,
I
you're
know.
very
I'm
disrespectful.
sorry. I need
know.
to make a record, because especially now that you threw me under a bus and you're blaming me for this.
I am blaming you
Fine.
for this.
And I know why, too, by the way. So, with
Because-
respect, Your Honor, I'm honestly going to think about withdrawing from my client so I can have a different attorney appear and try and get this order entered the way you like it. Because Joe Carasoni can do no wrong. I want you to please take a look at his order and find that you're not going to blame him for unintentionally omitting
I haven't even gotten-
minor flight order that his client complained about on January
Your
25th.
inability to comply with the way I asked you to do your motion for clarification...
Doesn't fit with the facts.
Stop.
Doesn't fit with
Stop.
the facts.
Your handling of my preparation order has kept me from even looking at his order. Because you just list a litany of things, pages that are wrong, you don't say why, you don't say what they should say.
Yes, I do say why. You're wrong. You know what, with respect, can you read my motion and we'll come back?
I have
Because
read your motion.
My client asked me why it appears that you haven't read it when we got here 3 times. She had asked me. And I said, I don't want to get
She
Judge
hasn't
Steele
done it
upset.
right.
She gets upset with me enough. But it's very clear you said, what's going on today? And I'm telling you,
I was hoping that you guys had come to something where I could give you guys an order and a hearing date, because this obviously is going to end up in a trial for evidentiary hearing on the fact of who is the primary custodian.
Okay, how about
And
this one?
in all reality, Miss Vaccarino, your client is closer to having primary custody than the other side. Sorry, counsel,
Yeah.
for making that declaration, because she's had the custody of the child the most time.
How about
So,
this one? Tell me what I do. The court orders that
you know what?
Caroline's
I'm going to
request-
step away from the bench for a minute, and when you can stop interrupting me, maybe I'll call the case again. We're off the record.